factors must be present for a person to be arrested for DUI manslaughter: impairment and death. Well, Hannah Ray's arrest included one of those factors, and it's not hard to guess which. The police on the scene said she was impaired by alcohol. Hannah and her toxicology report said she was stone cold sober. And now she's suing the city of Clearwater and the arresting officer, alleging false arrest, emotional distress, and a smear campaign that ruined her reputation. Hey, I'm America's attorney. I've been a lawyer for over 24 years. I've helped over 1.2 million people. And today, I'm taking a look at this crazy case. I mean, what a mess. When someone dies in a car crash, it's just a sad day for everyone. Imagine if you're the driver who's accidentally killed someone. The burden of that must be just awful. But the Clearwater cops figured out a way, as only cops can, to somehow make it worse. The young woman who finds herself at the center of this high-profile legal controversy is Hannah Ray from Pinellas County, Florida. On that early December morning, she was driving home from Tampa when she made a left-hand turn at an intersection that had been partially closed for construction. Her car collided with a motorcyclist, Jeffrey Connor, who was traveling through the intersection. Connor was killed in the crash, and Ray was arrested at the scene by Clearwater police officer Scott Yates. She was arrested on suspicion of DUI manslaughter. Shortly after the incident, the department published her mugshot on its official Twitter account, along with a caption stating that a Clearwater woman was charged with DUI manslaughter after she caused this crash that killed a motorcyclist. That post, which Ray says was both premature and misleading, remained online for over 6 months, even after the charges were dropped, based on toxicology reports that conclusively proved her sobriety. The department never issued a correction or retraction, and the internet did what the internet does. Ray's arrest was featured in numerous videos, social media posts, and news articles. As I already mentioned, in the early hours of December 4th, 2022, Hannah Ray made a left-hand turn into a closed section of a road at the intersection of US Highway 19 and Gulf to Bay Boulevard. During the turn, her vehicle collided with a motorcycle driven by Jeffrey Connor, who was killed in the crash. Clearwater police arrived on the scene within minutes, and Officer Scott Yates, a defendant in the lawsuit, conducted the investigation. Paramedics conducted an initial assessment of Hannah Ray and reported no signs of alcohol impairment. Despite this, Officer Scott Yates began documenting what he claimed were physical indicators of intoxication, including bloodshot eyes, glassy eyes, and mumbled speech. Ray was asked to perform field sobriety exercises roughly an hour after the crash, which she did, and these exercises were recorded on both dash cam and multiple body-worn cameras, providing over 4 hours of continuous footage. Dude, it's like Avatar, but no one was blue. Oh wait, the cops are blue. Anyways, according to the complaint, the video showed that Ray did not stumble, sway, or slur her speech. At no point, her lawyers argued, did she even appear intoxicated. Nonetheless, Officer Yates proceeded with the arrest for DUI manslaughter, relying in part on his obviously inaccurate observations. Later, Ray voluntarily submitted to 2 separate blood draws for toxicology testing. Those tests eventually and perfectly confirmed that she had no drugs or alcohol in her system at the time of the crash. In contrast, the deceased motorcyclist, Jeffrey Connor, was found to have a blood alcohol level of 0.214, nearly 3 times the legal limit. The police report made no mention of Connor's intoxication and instead focused solely on Ray's actions. Upon reviewing the toxicology results, the state attorney for the 6th Judicial Circuit in Pinellas County dropped the criminal charges against Ray, acknowledging that the evidence did not support the initial accusation. Yeah, that's an understatement. Is it possible that Officer Yates is so dumb that he thought that when the victim is drunk, that's also a DUI manslaughter? I don't know. Maybe? So what do you do when the whole world thinks you're a drunk driving killer because of a rushed, biased, and flawed investigation and a PR smear campaign? Allegedly. Obviously, you file a lawsuit, duh! That's why God created lawyers. Ray's first lawsuit was filed in September of 2024. However, the defendants, at that time that was only the city of Clearwater and Officer Scott Yates, successfully had the lawsuit dismissed in part, kind of. Their primary argument was that Ray's complaint was a shotgun pleading, a term used in federal court to describe complaints that are like overly vague, redundant, or improperly structured. Not that have like pump action. But anyways, specifically, they pointed to like a shotgun? Anyways, they pointed to a count directed at unnamed John Doe defendants and argued that the complaint failed to clearly specify who is being sued and for what actions. They also challenged the legal validity of each of Ray's claims. Ultimately, the court agreed in part, finding that the complaint needed to be rewritten due to its structural flaws and lack of specificity. but not that it was like morbidly flawed. And in fact, the judge gave Ray until July 17th of 2025 to file an amended version of the lawsuit, which she did on July 15th, 2025, and that's what we're talking about today. Ray's new lawsuit still includes the city of Clearwater and Scott Yates as defendants, but it also added Rob Shaw. The first claim is for false arrest under Florida state law, alleging that the city unlawfully detained her without probable cause. The core question is whether Officer Yates had arguable probable cause to arrest her for DUI manslaughter, which is the standard under both federal and Florida law. The Fourth Amendment and corresponding state law require that officers have a reasonable basis to believe that a crime has occurred before making an arrest. Ray argues that no such basis existed, given that the paramedics observed no signs of intoxication and that her field sobriety test showed no impairment. The second claim is a federal civil rights action under 42 U.S.C. Section 1983, accusing Officer Yates of violating her Fourth Amendment rights by arresting her without sufficient evidence. Now, this claim hinges on whether Officer Yates knowingly included false statements, such as claiming her eyes were glassy and her speech slurred, in his report to manufacture probable cause, which, if she is able to prove that, would violate her constitutional rights. The third and fourth claims target Yates again and Rob Shaw, the public information officer and Twitter troll for the Clearwater Police Department. Both claims are for intentional infliction of emotional distress based on the false statements in Yates's report and the trauma that Ray endured as a result of her arrest and the smear campaign. Both of those claims turn on whether Yates and Shaw acted with reckless disregard for Ray's well-being by not only arresting her without cause, but also publicly labeling her as a DUI killer on social media, which amplified the reputational damage. Now, Florida's sovereign immunity laws complicate those claims, shielding the city and its employees unless Ray can demonstrate malicious intent or conduct that was grossly indifferent to her rights. The fifth and final claim is another federal civil rights allegation under Section 1983, asserting a violation of her 14th Amendment rights based on the use of allegedly fabricated evidence to justify her arrest. If Ray's new complaint constitutes a properly pled amended complaint, the case will move forward into the discovery phase of the lawsuit. Both sides will exchange evidence, conduct depositions, including Ray's, which is already scheduled, and then they'll build their arguments from there. Now, the city and Officer Yates are likely to renew efforts to have the case dismissed on substantive grounds, especially invoking qualified and sovereign immunity defenses. But if the case or any of the claims survive dismissal, it could proceed to trial or potentially be resolved through a settlement. The city of Clearwater settled. Cases like this are tricky, and they often get dismissed on technical or procedural grounds in ways that really just kind of seem unjust. But as long as the lawyers for Ray can clear that hurdle to show that there's at least one viable claim that can be presented to a jury, there's a really good chance that some measure of justice can be achieved for Ray. $50,000. Although, if you just sit back and think about it, like if you were on the jury, is there any amount of money that you would be willing to receive as payment for the idea of your local police department labeling you as a drunk killer on their Twitter account for months and months and months? Probably not. Troublingly for the police department, they left that incorrect tweet up for months after the charges were dismissed. And I was saying earlier that she has to prove actual malice. Well, leaving that tweet up seems like malice to me. I bet you thought that this story was kind of over. Well, I certainly did. But since I filmed the first part of this video, I learned that the city of Clearwater settled Hannah Ray's case by paying her $50,000. That's not nothing. But Ray's lawyer said they thought the case was worth more than that. As a lawyer, I think it's super difficult to find that balancing line between advising a client of what you think a case is worth and what the client has the appetite to risk as they evaluate all their options. At the end of the day, the best lawyers let their clients make the decision for them, and they don't try to pressure them either way. Hey, those are my thoughts on the situation. If you have different thoughts on the situation, please let me know. Put your comments or questions down below, and while you're down there, don't forget to lawyer up with me, America's attorney, who is today in Chicago. I'll be back in the studio soon, and I hope to see you then. Take care. Based on flawed investigation and a period. Now, paramedics can get